the same ledger. Now, let's say you're a true debtor, and not only did you refuse to pay your credit card off, but you refused to pay the collection agency they passed it to after that, and now it's in court. So now the attorney for the collection agency files a complaint for money in the amount of $10,000. What is the asset in the bank? A court, by the way, a court is a bank. If you look up the definition of court and bank, you'll find court in bank and bank in court. It is a bank. You're in a bank. And everything's commercial, so they're treating it like banking. So, does anyone know what the asset is that opens up the liability that they're going to try to attach to you? What's the asset that creates the liability that they're going to try to attach to you, the defendant? The complaint. The original signed complaint. The original is, does anyone know where the original complaint is held? In the court. Where in the court? Because you're an attorney. When you take in a complaint, you file it, right? They keep the original, though, right? Yeah. Where does that original go from there? Judge's chambers. The judge has a vault in his chamber. And it's a vault. And it's because these are worth money. They are securities. So the judge is holding the security. So if you file a 1099-A on the asset, and you acquire the asset, the liability goes away, and they can't attach it to any parties. Simple accounting. Okay? Go ahead. Oh, microphone in the back. Who's got the microphone? You guys can't see, huh? Yeah. I'll try one of the new ones.
I was wondering, when you do that and you 1099-A that in the court, is that all paperwork before you even get into the courtroom? Is that something you file ahead of time, or would you do that?
It's something I would file ahead of time. Well, unless there's no amount. I mean, I've seen cases filed where they haven't attached an amount to it yet. Then it's a little tricky, because there is a security sitting there, but because the amount hasn't been put in there yet, you don't know what to claim.
Could you just put a big one?
You could. and the rule of thumb is 300 million.
Yeah, should cover it.
Yeah. So 300 million should cover it. If you've got multiple federal felony criminal charges, you would actually be talking about a lot more. Probably 400 million per charge.
In order for a check to become a security, you need 3 things on the check, right?
What are those?
One is a signature, and there's 2 other things, isn't there?
Okay, so we're talking about a money order, really, because all negotiable instruments are money orders. So, what's essential on a money order?
Date, contract.
Oh, that's a good one. You guys got one. It should actually be above the line I'm writing. Okay, so put date, the issue date, date of issue. Date. We'll say Jan 15th. Not me. 2009. Okay, what else? Accounts. We'll put the accounts at the bottom.
The 2 signatures.
2 signatures. Why do you need 2 signatures on this instrument?
Contractuals between the 2.
No, we're just talking about the most basic negotiable instrument.
Signature.
Signature. Okay, well, we'll do pay the amount first. Pay $10. And then you'd write $10. Right? Okay. Who's it going to? Pay to the order of. Pay to the order of. And Todd. He was the first one to claim the abandoned property. Okay. Account, somebody said. Memo. 1, 2, 3, 4, 5, 6, 7, 8, 9. And signature. That's all you need. That is a money order. So whenever you hear me talking about money orders, I literally will write one just like that. Doesn't need to be any fancier than that. Date, pay this amount, pay it to this guy from this account. There's my signature. I authorize the creation of credit, just like I do when I sign a promissory note. You're just authorizing the use of your credit to create an asset. What about a traffic ticket?
Said or a traffic ticket?
Yeah, when you sign a traffic ticket, it's a money order. A traffic ticket is a money order.
Except for
It's an order for money. What is a law called before it becomes a law? It's a bill.
Yeah.
Okay, so there's a pyramid of law. Okay, the top of the pyramid is what I would call natural law. And natural law is what makes it possible for your various elements of the earth to come together and form the experience that is you. Okay? So there's first natural law. From natural law, you get things like human beings and cats and dogs and things like that. As soon as human beings started interacting with each other, that created the second highest form of law, which is commercial law. Why do you think that that's the second? And actually here, I'll give you a great example of when we transition from this to this in the Bible. In the Bible, we started out with natural law in a non-commercial zone known as Eden. There was no debt, there was no commerce. Okay? However, God gave the law. And one of the laws was that if you eat from this tree, you will surely die. Okay? And at the moment they ate from the tree, did God kill Adam and Eve? No. They immediately traversed into a new jurisdiction. And that traversal created commercial law. And not only did they traverse, but it really was the foundation of what we call admiralty law. Okay? Because in admiralty, you can discharge a debt. There is no execution on a contract in admiralty. Okay? In what is commonly known as common law and law of the land, there's always execution on the contract. Whereas in admiralty, there's discharge of your debts. So God gave them the option to discharge their debts with the blood of animals. That was the money of account that he accepted. Oh, we didn't go into money of account, money exchange. It's actually money of exchange. Okay? Your current forms of money of exchange are Federal Reserve notes, checks, credit cards, debit cards. That's money of exchange. Okay? When you write a promissory note, it's a credit instrument and is money of account. Okay?
Say that one more time when you write
A promissory note and put it in, that's money of account. Okay? So basically, they were given the opportunity to, and rather than die for their sins immediately with execution on the law, the option to discharge their debts. Now, does discharge get rid of the debt? No. It sets it off to a future date. Okay? And that's what you're doing in commerce right now. You never really pay anything. You're always discharging a debt. You're offsetting you're discharging the debts and your sins to be paid for at a future date. Okay?
That's not how we got the problem in the first place.
So then the next on the pyramid, I guess would be common law.
Where's admiralty law, or is that commercial?
It falls into both of these, actually. See, admiralty is more of a jurisdiction, not a law form. But admiralty is where realistically, we've operated in and out of admiralty throughout history. Admiralty became really popular in the 1500s when we started sending ships out across the sea, and things like insurance and stock and all forms of negotiable instruments. That's really when admiralty came into being the common law. And it was officially declared common law by Lord Mansfield in 1753. He said basically, yeah, admiralty is part of the common law now. There's too much of it going on for it to not be considered common law. And then, as through the 15 and 1600s, they realized during this spiritual evolution of humankind that all people are vessels in the sea of space. And there's no more appropriate law form for vessels in the sea of space than that of admiralty. So they basically, your body's a vessel, but you are not your body. You're the captain of the vessel, but you don't physically exist in this world.
Is that what Jesus taught us or showed us when he walked on water?
Walking on water, I would say it's also a metaphor for having a command of admiralty. I walk on water, I don't sink.
Can we be spaceships instead of boats?
It's a vessel. I didn't say anything about it being a boat. You associated it with a boat. Okay, so after common law, next step down on the ladder would be good old, I'm thinking, statutory law. Now, statutory law, well, first, actually, we didn't really go into common law too much. Common law is like a group of people get together and decide this is how things are going to go, and common law is also how things have been done in the past. So common law is kind of an amalgamation of what we generally agree as a society and how we've based our judgments of commerce in the past. So that's really common law. Whenever you hear like reference to past court cases, you know, they call that case law. That's part of the common law. It's not that it's necessarily written in a book anywhere. They're just saying this is the maxims of law for our society. This is generally accepted. This is how we do it.
Eye for an eye?
Eye for an eye. Common law of the land. See, now because common law has kind of been mixed with admiralty, you've heard of the law eye for an eye. Okay? And that was the old biblical law, the Old Testament, the old contract, which was execution of contract, which used to be known as common law, but now because common law involves admiralty, it's to distinguish between the two, we'll call it law of the land versus admiralty. And the law of the land was when you owed, you paid. You couldn't discharge it to a future date. It happened now. If you can't pay now, well, then you're working for me. You become my involuntary slave until the debt is paid.
So then that would be part of natural law or natural law forms? Is that the jurisdiction of natural law forms?
No. Law
Okay.
of the land? Law of the land is a common law. It's
Okay.
what we decide as a people to participate in.
So common law would then have two subdivisions, law of the land, law of the sea.
Possibly. There may be more to it, but you could divide those up, but you could also do the same with commercial, you know. And then statutory law is laws recorded in code, in statute, in the various, let's say you get a society of people or an association of people, and let's call that association of people the United States. The United States decided that we were going to publish the general guidelines of operating within the United States, and we call that the U.S. Code. And then each of the states have their own code forms, and we've got government code and tax code and all these different codes, and that falls really way down here on statutory law. Now, because you have unlimited right to contract, you originally were up here in all your dealings with people. I mean, really, the original jurisdiction is up here, but contract doesn't happen up here. As soon as you get into contract, it happens here. Okay? Exactly. Interaction even. It doesn't even involve language. Because if we, it's really contract. See, people think a contract is written or signed.
That's the last language.
No, that's just a memorialization of the contract. Contract is by agreement and is by performance. If I say to you, you're going to pay me $20. Anyone hear a rebuttal? No, she just agreed to pay me $20 because she didn't respond at all. The fact that she stayed silent means that she agreed. That's a maxim of law.
Isn't that like an invisible contract?
Yeah. But again, remember, contract is strictly by performance. If you're accepting a benefit of the United States, you're in contract with them, whether it's signed on a piece of paper or not. The fact is, you're operating a trust known as a U.S. citizen, and that trust receives benefits from the U.S. corporation, and because you're accepting the benefits, you've agreed to be part of these laws right here, or to act within the bounds of those laws. They didn't have to get you to sign the statutes. That's the application for live birth. They're saying, hey, there's this new commercial unit in the world, and we need to get it a berth, B-E-R-T-H, in Admiralty. It needs to be able to sail the seas of commerce as all the other vessels can and do business. Can you please register our vessel? They said, sure, we'll register your vessel. And they gave you a birth certificate. Okay? And then the last form of law, I would say, is political, or the lowest on the totem pole is political law. And the example I used last time was soccer. Soccer, and the reason I like soccer is because, one, I play it, and I loved it, and I played it for my whole life, but I also refereed it. Being a referee in soccer, you're trained to be a judge. And as a judge, you're only concerned with the laws of the game. However, not one of the laws is black and white. It's all interpretation, which is exactly what you're dealing with in the courtrooms. That's why things never quite seem to go the way you think they're going to go, because the judge is a referee. He's looking at your intent. He's looking at your action. He's not only looking at the act, because the act could be harmless, whereas if the intent is harmful, he's looking at that. And remember, I used the example of Solomon, King Solomon in the Bible, when the two women fighting over the child came before him as the judge, and his only responsibility is determining who's the creditor, who's the debtor, because the creditor is going to get the remedy, or the creditor is going to get the benefit of his decision. Because the creditors creditors win, debtors lose. That's just how it is. Creditors control, debtors are controlled. Okay? So he said, how about we just chop the baby in half? And the one lady's all, no, 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 don't do that. Give it to her, that's fine, but please don't cut the baby in half. She can have it. Who got the baby? She did. She did. Because she was willing to risk it all. She's a creditor. Creditors are willing to risk it all. Okay? So, yeah, she brought resolution. She brought the remedy. Yeah, so that makes her a creditor as well. So you see that being the creditor isn't always the one who brings money. You bring remedy, you bring resolution, but it doesn't mean you bring Federal Reserve notes in your pocket.
Other questions?
Mm-hmm.
You said judges are the referees.
Yes.
Isn't that in a perfect ideological world?
Yes, because really they're bankers in our world.
Right. Well, so, but like for example, in the Winston Shrout stuff, if you call which jurisdiction they're in, you can actually being a creditor, you can ask them what jurisdiction they're operating in, and it will force them to own, whether being a referee or a banker. Isn't that, I'm not being rough about it.
But do we need to go there? Because no
Well, I
matter
don't know.
where they're at, we're there as creditors to bring a resolution. So if they're there as a banker, good. Here's my money order. Take care of this. I'm out of here.
Okay.
If he's there as a judge, well, I'm not there to argue anyway. So here's my evidence. I agree and accept everything they say. Here's the remedy. Or here's my evidence. But if you're going in there for controversy, adversarial, anything to oppose anyone in there, you're a debtor, and you're going to lose.
And even then,
Yeah, and even then. Okay, so let's do a little what I like to call jurisdiction A, jurisdiction B, because I always talk about that, but I know that it's because I've listened to so much Jack Smith. To me, it means something, but to most, it probably has absolutely no meaning. Okay, so jurisdiction A would be the equivalent of de jure. Jurisdiction B would be, and there's actually a space in there, de facto. Jurisdiction A would be the republic. Oops. Jurisdiction B would be the democracy. Come on, work with me. Jurisdiction A would be, what's another way of breaking it down? Private. Jurisdiction B would be public. Yeah, well, that's the trust. We could break down the trust again, too. All right. So, jurisdiction A, which is where the United States originally, in 1776, existed, we'll say. Okay? Now, since then, everything that's public or part of the government is over here in jurisdiction B. The only remnants of the republic in jurisdiction A, post office, secretary of treasury, and really the post office is on both sides. Well, actually, the post office is over here. The postal service is over here. The secretary of the treasury, the secretary of state, and the attorney general all sit over here in jurisdiction A. They actually had to expatriate their citizenships to serve in those positions. And it's because they're the last remnants of the republic.
That's the exemption of foreign sovereign, sorry, I'm screwing it up. Isn't that the Foreign Sovereign Immunities Act? Is what they did for A, is to become expatriated?
No, they just expatriated. I don't know if it had anything to do with the Foreign Sovereign Immunities Act,
Yeah.
because their positions have existed a lot longer than the Foreign Sovereign Immunities Act. So
Okay.
the Foreign Sovereign Immunities Act has to do with foreign sovereigns, but what's a sovereign? Anyone know what a sovereign is? It's actually really simple.
Emancipated person who knows their rights, or a free man.
Are you taking a position that anyone can take those things away from you? Or that anybody has control over you?
No. No.
Okay, so what's a
Originally,
sovereign?
no.
Okay, well,
A
are
sovereign
you
is-
suggesting that now that you don't have that?
Ask me the question again. Ask it
Give
again.
me your answer again.
Okay, so sovereign is free, emancipated from myself, and others.
Free from others.
Yeah.
Okay. And what is evidence of that? What demonstrates that?
My will, my knowledge,
Your
My
will.
faith.
So don't you always have your will and your knowledge and your
Yep,
faith?
yep.
No matter what?
Yep.
So what makes you a sovereign?
Isn't it free from the system that was created to
Who created it?
our environment, our city, or wherever we are functioning, created this system that we have to supposedly follow. So when we're sovereign, we don't follow that, but we also can benefit from that.
But
So we're
who
completely
created it, though?
man, people.
Aren't you one of those?
Yes,
Okay.
but sovereignty in that sense. Is that what
So
you're talking
are you
about?
saying your creation controls you?
Yeah,
Are you taking a position that your creation can control you?
yeah. In this case, yes.
Okay, so you believe that that your creation controls you. Okay. Sovereignty. So being a sovereign would be not being controlled? Is that your position?
Yeah, not being controlled.
Okay. Basically, my simple definition of what a sovereign is in control. You control your property. If you don't control your property, you're not sovereign.
No, no.
If you don't control your property, somebody else does. So what's that make you? Debtor in possession. Right? Right. So you're debtor in possession, so you really have no sovereignty. Sovereignty is just about control. Do you control your life? Do you control your body? Do you control the things in your life? That makes you sovereign. And you have absolute control. We like to pretend like we don't, because that's a whole lot of responsibility when you look out at the world and you say, oh, this is what I created. This is what I'm responsible for. And that's why it's real easy for people to go, no, it's the devil, and it's the Rothschilds, and it's the Bushes. And
Forget the Illuminati.
well, I mentioned a couple of them.
So own no thing and control everything?
Own no thing and control everything. That's being truly a sovereign. So, how many people think Rothschild controls the world?
What?
Good. Because he doesn't. He's chosen to take a much higher level of responsibility than all of you, but that's it. That's the only difference between you and the Rothschild family, is that they take a very high level of responsibility. That's it. Same with the Queen of England. She takes pretty high level of responsibility. Pope, high level of responsibility. Brandon?
What were the three secretaries? There was the Secretary of State, Secretary of Treasury, and what was the other one on the A side?
Attorney General.
Attorney General.
And I mean, we can go into that and how and why they are what they are and how they operate. But easiest way to put it is they're foreign agents. And jurisdiction A is always foreign to jurisdiction B. And jurisdiction B is foreign to jurisdiction A. However, B was created in A. So B is the creation of A. Can a creation control its creator? No.
Sure does good.
So ultimate control in commerce comes from which jurisdiction? A. You can't control over here in B, because B is a creation of A. So B is always controlled by A. So who controls the country? Who controls jurisdiction B?
Creditors.
The creditors. And who represents the creditors in the United States?
Rothschild.
Secretary of Treasury,
Yeah.
Secretary of State, Attorney General. They represent the interests of the creditors. Who's the IRS collecting money for? Creditors. Do creditors pay taxes? No, they get your taxes.
Yeah.
You pay the taxes, creditors receive them. Creditors don't pay taxes. And when you learn to be a creditor to the United States, you'll never owe them another tax dollar again. They'll be paying you big bucks because they'll be returning your principal. That's their job. They're there to work for any creditor. That's the beauty of it. IRS is your best friend. Love them. Because if you're a creditor, they're out there working their butts off for you. Revenuing. That's the internal revenue service. They're revenuing from private to public, from public to private. That's their job, moving the funds from one side to the other.
Just a quick question. Is the reason that Secretary of State, Attorney General, Secretary of Treasury, foreign agents, is that the way that they can then communicate with Jurisdiction B, because they've expatriated?
Well, if they can communicate with B before they
But as
expatriate.
creditors and debtors, that there's a gap in communication.
But everyone in B can communicate with each other, and everything in B is public. So
Right.
they were there before. So who couldn't
So they
they communicate?
expatriated from B into A,
Because
so they could communicate, because they're creditors, and because they can then...
no, they're not the creditors.
They're not?
No, they
They
represent,
represent
the
the
creditors.
creditors, okay.
So they needed to talk to people in what jurisdiction?
B,
No, where are the creditors at?
well, A.
So that's why they
That's
had
why
to get
they're-
out of here. They had to get out of B.
But
They
then
can't interact with these people over here.
Okay, but
They'd
they're
actually-
B who became A, but then they can communicate with both.
Right.
Okay.
But they'd actually, if they were over here and in acknowledging what's over here, they could be hung. That's why a judge in jurisdiction B can never recognize jurisdiction A because he's committing treason against jurisdiction A.
Right,
Okay?
right.
So that's why you can't bring your private process into a public hearing and expect anything to happen, but you're delusional. Because he's protecting everyone in that room. His job, the judge's #1 job, protect the public. And if you go in there and start talking about stuff over here, yeah, he ain't going to listen to a damn word you say, and he'll probably throw you in jail real fast because you're damaging the public. He can have you can say something that gets if he says the wrong thing, him and every attorney in that room could be hung.
What was that acronym?
Hanged.
What was that acronym we had with people, like it's something reality disorder or alternate reality disorder?
Right, alternate reality disorder. Yeah, you walk into jurisdiction B, talking about jurisdiction A, you have what they now call alternate reality disorder.
Was there a year that these Secretary of State, Treasurer, and Attorney General, it was required for them to expatriate themselves? I mean, was that always from the beginning of our country?
No,
or was
it wasn't
that
from the beginning.
like 1933?
It would have either happened in 1859, the end of the first bankruptcy,
Right.
or 1929, the second bankruptcy. See, in 1859, who lost their sovereignty? Well, let's go back to the first bankruptcy. Who lost their sovereignty in the first bankruptcy?
The entire country.
The national government. No, not the entire country. The national government, which had just been created. It was only 7 years old.
1782, right? Or 17...
Yeah, 1782 was when the national government was created. Actually, you may consider, officially created in 1782. 7 years later, no one would pay the debt. They went into the first bankruptcy in 1789. International bankruptcies run for 70 years. Fast forward 70 years, we get to 1859. What happened in 1859? The Civil War. Who lost their sovereignty? The states lost their sovereignty during the Civil War. So it may have happened then, but probably more likely it happened in the beginning of the third bankruptcy in 1929, fall of the stock market, the New Deal, and you're about to get a new Deal. And this New Deal isn't going to be as good as the last one, if you consider the last one good.
I was just going to say, okay, so 1859, the states lost their sovereignty,
Yes.
and then in 1929,
The people.
lost their
The
sovereignty.
people lost their sovereignty in
And then in
1929. But they gave you something in exchange. Remember, they can't just take something from you without giving you something of equal or greater value in exchange. And they gave you the power to create money.
Okay.
They said,
In
we're taking
1929.
away all your legal titles, which creates what? Fascism. If the government has all the legal titles, that's fascism. However, they gave you something in exchange. They said, but you're in charge of creating all the money. So we're going to take away your gold, we're going to take away your silver, we're going to take away your legal titles, but here's the benefit. You get to create all the money.
To become bankers.
Yeah.
So then in 1999,
1999.
who lost sovereignty?
1999. Well, I don't know. We're moving into a new deal. I guess we'll see. But I don't imagine it's going to get any better for the debtors. It's not going to change for the creditors because it never does.
I think we lost who we are.
Well, if you're a creditor, no matter what stage in history you're in, you're a creditor. And none of those bankruptcies or fictions or insolvent entities have any effect on you. You operate outside of them. You're feeding them. You're the one helping them out. You're coming with the solution.
But I think it's becoming, I think in 1999 it became a spiritual loss.
You think
No,
so?
really, like
Spiritual sovereignty.
people losing who they are.
Well, what did we
and as a
lose?
result,
What
their
did we
health
lose
or their-
control of? Realistically, I think probably what happened
minds.
in 1999. I think you got to look at what was really going on with the Clinton hearings, because it probably has something to do with that, because that's what was happening. Remember, in history, it always seems like something else is happening, whether it was their signing of the Constitution in 1789, or the beginning of the Civil War in 1859, or the crash of the stock market in 1929. Let's look. What was happening in 1999?
The trade towers were shortly thereafter, too.
Right, they were, but that was probably more about destroying documents, evidence, titles.
Yeah.
Because I noticed something interesting is the Queen lost her crown on Canadian money for a little while after the towers came down. She lost her title, right? Doesn't the crown represent title? She probably lost some title documents.
Well, the Enron documents and investigation supposedly.
Yeah, there was something there. But remember, War of 1812, when we refused to renew the Bank of the United States. Yeah, the British soldiers came over here and went into the federal courts because that's where we hold title. They wanted the titles. That's all it was ever about. That's what the Constitution's all about. We gave title to the national government to foreign creditors. And people want to stand behind the Constitution like it's a great document. It's a debt instrument. It's a negotiable debt instrument. That's all it is. It says somebody else, this country owes somebody else a lot of money.
A lot of money.
Yeah, and the states are the sureties because they signed on as sureties. Remember, each person who signed the Constitution was representing a state. When the states refused to pay the debt, they lost their sovereignty with the beginning of the Civil War.